Where a crime may have been committed, then it's dealt with by the criminal justice system. In English law, crimes are considered to be committed against society, and the state prosecutes in almost all criminal cases. Important cases are recorded in law reports and given a case citation. In criminal law, cases are usually written as the king or queen as head of state against the alleged criminal. Latin is still used, so the king is referred to as Rex and the queen as Regina, and this is cited as RV. But when speaking in court, lawyers read that RV as the Crown and. Because the state is usually a party in criminal law cases, criminal law is also regarded as public law. The role of the police is to investigate alleged crimes. This may well involve talking to suspects and witnesses. If the police believe a criminal offence has been committed, then they will refer the case to the Crown Prosecution Service, known as the CPS. It's the CPS's job to decide whether or not to prosecute. If a decision is made to prosecute, then the accused, called the defendant, will face trial in the criminal courts. The Crown Prosecutor uses two tests to decide whether or not to proceed with a charge. These are the evidential test and the public interest test. The evidential test looks at whether there is a realistic prospect of conviction, whereas the public interest test looks at how serious the offence is, whether prosecution is likely to be in the public interest, for instance, is a conviction likely to result in a significant sentence, and it might also consider whether a weapon was used or violence threatened during the offence, and whether the offence was committed against a person serving the public. If a prosecution is less likely to succeed, and if the loss or harm is minor, then the Crown Prosecutor may decide to drop a charge.
All rise.
Because criminal law allows for individuals to be punished, or in extreme cases to be locked up in prison, a higher standard of proof is required than in civil cases. In civil law, the person bringing the case, called the claimant, has to prove their case on the balance of probabilities. This means that it's more likely than not. In criminal law, the court must be convinced beyond reasonable doubt that the alleged wrongdoer, called the defendant, committed the crime. The courts in the English legal system can be classified as courts of first instance and courts of appellate jurisdiction. This means the court of first instance is the trial court, and the appellate court is where appeals are heard. Some courts, as we shall see, can do both. They are said to have hybrid jurisdiction. Criminal courts of first instance are magistrates' courts and Crown courts, whereas appeals can be heard in the Crown Court, the High Court, the Court of Appeal, and the Supreme Court. What you are watching is taking place in the Magistrates' Court.
Yeah, that's fine. Okay. I'm a magistrate. I volunteer my time to hear civil and family cases and criminal cases in the community. Magistrates aren't paid, but my employer gives me paid time off because she can see the value of the work that I do. Before I first sat as a magistrate, I had to do 21 hours of training. We usually hear cases in groups of 3.
I'm also a magistrate. I have to take additional training as a chairperson. We don't do any training on the law, but have to rely on the clerk to the courts and also for our bench book. To be a magistrate, you must be between the ages of 18 and 65, but when you reach 70, you must retire. You'll be good at hearing, good of concentration on the cases, demonstrate the right personal qualities and be of good character.
As magistrates, we deal with some civil cases, and all criminal cases start in the magistrates' court. Depending on the seriousness of the offence, we may pass the case up the court hierarchy, but around 98% of all criminal cases are dealt with by us at the magistrates' court, as we have jurisdiction in respect of trial summary offences, something called either way offences, and indictable only offences.
I'm the clerk to the magistrates. My job is to help the magistrates with questions of law. As I am legally qualified, I can explain many types of criminal offences that are heard here. Summary offences are dealt with summarily, literally, briefly, without a jury, in the magistrates' courts. These are less serious offences, such as many motoring offences under the Road Traffic Act, like taking a vehicle without consent and many other offences created by statute. Offences triable either way are crimes that are tried by a magistrate or by a judge and jury. They are often referred to as hybrid offences. They include, for example, less serious assaults, criminal damage, and many of the offences contained in the Theft Act 1968. Offences triable only on indictment are tried only in the Crown Court. These are offences which are considered too serious to be dealt with here by the magistrates and must be heard by a judge and jury. Examples of these offences include murder, manslaughter, rape, and aggravated burglary.
In this case, the magistrates decided the offence was too serious for them to deal with and referred it up the criminal court hierarchy to the Crown Court.
Please sit. Send the defendant in. You may be seated. Welcome to Northampton Crown Court. The Crown Court sits in court centres throughout England and Wales. The most famous Crown Court in London is referred to as the Central Criminal Court, popularly known as the Old Bailey. The Crown Court is regarded as a single court which sits throughout the country, its distinctive feature being the use of the jury as part of the trial process. It has the power to sentence persons convicted by the magistrates and to hear more serious criminal cases.
I am the jury foreman, and like all the members of the jury, I am a member of the local community, selected at random for the electoral register. If you're called to do jury service, then you must, and you may be fined if you don't. We don't get paid for jury service, but you can claim expenses like travel, food, drink, and any loss of income. We aren't allowed to discuss the case during the trial except with the other jury members. We must never speak to anyone outside the jury about what has occurred in the deliberation room. Breaching these rules is a contempt of court, and we could go to prison. The judges also warned us about discussing the case on social media like Facebook and Twitter.
In the Crown Court, the jury determines questions of fact, such as what happened, to whom and when, and the judge decides questions of law, including the admissibility of evidence and the directions to be given to the jury about the law.